somebody directed me to the humble merchant stream where he was peddling his wares, selling his goods, and you can get in on this action. He's got a $1 million flexible goal. He hasn't raised any money yet. It's the American Justice Corporation. It's the American Justice Corporation. I mean, what's wrong with American Justice Corporations, right? But for $25, if you get in at the featured level, $25 USD plus shipping, $25 USD plus shipping, you can get a mini video camera. Now these normally sell on eBay for around $10, but they get them in bulk from China for a few bucks each. And this is 2 years ago, so these are like 2+ year old, couple dollar video cameras. I'm sure they're amazing. Anyway, help the humble merchant, because he has 20 years of pro se experience, where he is, as near as I can tell, not won a single case. But he's on your side, and that's important. I gave him a little bit of sass about his 20 years of pro se experience, and somebody decided they wanted to defend him, and now I normally wouldn't care about that, but they brought up cases, and I love cases because I read them. That's the difference between me and most other people, is I'll read the cases. Anyway, he says NAACP v. Button and Sims v. Aarons, anyone can practice law to help assert civil rights without degree. I think what he means is without being a member of the bar, because the degree doesn't make you the lawyer. You have to be the member of the bar. You could theoretically become the member of the California State Bar without a law degree. If you've apprentice with a lawyer, and eventually they'll sign off. They may sign off that you have the equivalent of a law degree, and then if the state bar accepts that, then off you go. You can go sit for the bar, which means you have to take the test where they test to make sure you actually have the knowledge you need, which pro se litigants don't have to take a test. So you have no idea if they have the knowledge that you need. But let's look at these cases, because he's bringing them up, and I like to look at cases. Versus Sims v. Aarons. This is a Arkansas Supreme Court case from 1925. It's meaningless. It's about taxation. The only thing I could think of is, because they don't mention civil rights in here, it's not about civil rights. It's not about anything except for taxation. And they're banging on about Article 16, Section 2 of the 1874 Constitution. Here we go. And they say that it limits taxation for state purposes, taxes on property and taxes on privileges. This is the Article 16 of the Arkansas Constitution of 1874, and now Section 2 says the General Assembly shall from time to time provide for payment of all just and legal debts of the state, but it doesn't limit it. So it's old. It doesn't mean anything anymore. The only thing I can think of is it does talk about licenses in here, but in Arkansas you still have to get a license to be an attorney. It's par for the course. So I'll link it. You could read it. You tell me how I'm wrong. The other case is NAACP v. Button. Again, this has nothing to do with laypersons litigating. The NAACP in this case had staff attorneys. They had a legal staff of 15 attorneys. It's the legal staff who lawyer. There's attorney. I mean, it's... Oh, and hey, Felipe, you might want to notice how they use lawyer and attorney interchangeably in the Supreme Court case, so you might want to rethink your statement that there's a difference between lawyers and attorneys, because there isn't. So, suck it. Anyway, yeah, so 15 attorneys, blah, blah, blah. Pays each lawyer per case, interchangeable. But yeah, it's not about laypersons. There was a concern in here that laypersons, because the conference decides what cases it will take, and the conference requires that any of these cases that they pay these attorneys to litigate for you. But you have to be a Negro, and you have to have some litigation that is based where you're trying to get fully desegregated public school facilities, and you have to basically they just have criteria you have to meet. And so Virginia was worried that lay people, meaning not the 15 lawyers, but other members of the NAACP, would be saying which cases the lawyers could take and et cetera, or which cases they would pay for, and they thought that might be interfering in it. But nowhere in this does it state that non-lawyers can practice law. Nowhere. It doesn't state that. It does not state that at all. The NAACP used lawyers. It was using lawyers to litigate. There's nothing in here says that a non-lawyer can practice law, period. So again, I'll link everything. Thank you to Upstate New York Audits for giving us those cases to look at. And thank you to the Humble Merchant for giving us this lovely hours-long infomercial about his KopCam. Thanks for watching and have a great day.